Coming up next on Arizona Horizon, we'll take a closer look at last week's court ruling. The Maricopa County Sheriff's Office engaged in racial profiling. We'll learn more about a court ruling earlier this month regarding a proposed tribal casino near Glendale. And a tax expert discusses the impact of U.S. companies shifting profits and expenses to other countries. Those stories next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Eight, members of your Arizona PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. A federal judge ruled Friday that Maricopa County Sheriff Joe Arpaio's office engaged in racial profiling and that the practice must be stopped. Here to tell us more is J.J. Hensley, who's been covering the story for the Arizona Republic. And you have been covering this. This is quite a job you've been doing here. Give us kind of an overview of what did U.S. District Judge Murray Snow rule.
Overview is key. It's a 142-page ruling, very detailed. But, I mean, the big takeaway were the kind of 7 particular items that he prohibits the sheriff's office from doing now as part of his injunction. One of them is they can't call ICE anymore when they have someone detained on the side of the road without an underlying state charge. So if there's no speeding or jaywalking or drugs, then there's no call to ICE. And that's probably the most significant immediate impact. I think the sheriff's office is still trying to suss out exactly what this is going to mean for their worksite enforcement operations, for any kind of patrolling that they might do on the highways around here.
I want to get more to those kinds of factors in a second here, but this trial was, I think it wrapped up, 8 months ago or something like that? What took so long for this ruling?
Well, that's a good question. I mean, and a lot of people who I've talked to said, boy, I was surprised it took that long. And then when you say, well, what do you think about the ruling? They're like, man, it was detailed.
Yeah.
And I think that that's the key. I mean, he took point by point through what they said on the stand and then went to the reference material that the sheriff's office provided and that the ACLU provided and then drew on outside resources and was able to kind of take each issue and distinctly discuss it and suss out the legal arguments there. And I mean, it's thorough and detailed, and I think that's why it took more than 8 months to come down.
And just to be clear, the judge really was the only arbiter, correct? No jury here?
No jury, just a judge in a bench trial. They were asking for injunctive relief to prevent the sheriff's office from engaging in this discriminatory policing, and that's what Snow has done.
And what do we know about Murray Snow?
He was a Bush appointee. He went to law school and undergrad at BYU, so I would say that his point of view on a lot of issues should mirror that of a lot of Arizonans. Interesting.
And this, you said detailed and obviously comprehensive. Was it clear? Was it a clear ruling?
Yeah. I think it was everyone I've talked to who's kind of got a national perspective on this thinks it was a very thorough rebuke of this inherent authority philosophy that we've come to discuss in Arizona, particularly in the last 6 years when it comes to immigration enforcement. Our local law enforcement agencies, do they have the inherent authority to enforce federal immigration law? Chris Kobach, the Secretary of State in Kansas, the one who trained MCSO on this immigration enforcement, he says yes. Judge Snow says no, and he took it point by point to say why that's not the case.
Real quickly, remind us who the plaintiffs in this case were.
Sure. There was a group of individuals that started with one person who was here on a tourist visa who got picked up outside a church in Cave Creek in '07 as a day labor work site. It expanded to include 5 other plaintiffs. Then the judge opened it up to a class of all Latino residents who were stopped by the sheriff's office since 2007. But there was no money involved here. They weren't seeking any monetary relief, just injunctive relief, which is what Snow gave them.
And it's exactly what they gave. And it's basically equal protection, 14th Amendment kind of a thing, correct?
Yeah, there was a 14th Amendment, and then there was a 4th Amendment issue on search and seizure as well.
So what was the Maricopa County Sheriff's Office, what were their arguments in this, and how much did those arguments wind up in that court ruling?
I think one of their main arguments was this is the way that we've been trained, and this training came directly from ICE, that we can use ethnicity as one factor among many in helping us develop reasonable suspicion of someone's legal status in the country. Judge Snow said, that might have been the training you got, but that training was wrong. And it's been the training that you've operated under for a number of years, and so it's going to take some corrective action to rectify that.
And again, can't check on status of detained that aren't charged, and basically you can't use ancestry or race for law enforcement decisions regarding status. That's kind of the bottom line here, right?
Yeah, that's the theme of this, that you shouldn't be making any decisions on law enforcement maneuvers based on anyone's ethnicity or race. And this goes, even back to some of the issues that came up in the trial where there are letters that are presented to the sheriff's office from concerned citizens in the Southeast Valley saying there are a group of Hispanic men standing on the street corner, please come do a raid, and with 2 days there's a raid. And so Snow took exception to that. And I think that really came through in this ruling.
How much did what Sheriff Joe Arpaio, who's never been shy around cameras and microphones, says a lot and is quoted a lot, how much were those quotes at play in this whole thing?
It ended up playing a big role. And that might be why we haven't heard from him since this was handed down. He's been conspicuously quiet for him. But, throughout the ruling, Snow would take the statements Arpaio made in 07, 08, 09 and contrast them with what his deputies or he himself was trying to say on the stand, and basically said these can't both be true. So your contemporaneous statements that this is a pure immigration enforcement effort, that it's the only one that really targets illegal immigration in the United States, when he launched this, that's really what Snow kind of hung his hat on, and it really came back to bite the sheriff.
So with this kind of comprehensive ruling, this kind of detail and clarity, are we likely to see some sort of appeal here?
They promised to appeal. The legal experts, I guess, who've reviewed this say that there's not a lot of room for appeal here, that it's pretty factually based, not on Snow's kind of point of view or his judicial philosophy. And so it's going to be tough, but they've vowed to appeal. And, when you listen to Arpaio's attorney, it sounds like he wants to take it all the way to the Supreme Court.
Last question. Speaking of the feds, Department of Justice case, that's still out here. How does this impact that case?
I think in one immediate, potentially significant way, immediately. There's a hearing coming up on June 14th where they're going to talk about remedies. Where the ACLU will come in with its proposed remedies, MCSO will say, no, we can't stand for that, and judge will kind of determine who's right there. Among those things, he could appoint a monitor there to oversee this. That's an issue that's been the subject of the main dispute between the Justice Department and MCSO on their civil rights lawsuit. So let's say Snow appoints a monitor, then suddenly that issue is resolved with DOJ. So it could be an issue where some of the remedies that are ordered here resolve some of the issues that are in dispute in that case.
So instead of piling on evidence, it basically kind of runs the back door here and takes care of some of the remedies.
Yeah, but we've got another, we waited 8 months for this, so we'll wait another 3 weeks to sort that out.
Well, we've got to keep you busy. Thank you so much. Great stuff. Good to have you here.
My pleasure.
The Tohono O'odham Indian Tribe's plans to build a casino on land near Glendale have survived several court challenges, including a federal court summary judgment that favored the tribe just 3 weeks ago. For more on the legal aspects of this issue, we're joined by Heidi McNeil Stoudenmeyer of the law firm Snell and Wilmer. It's good to have you here. Thanks for joining us.
Thank you.
What is the current status of this dispute?
Well, there's actually about multiple prongs that are going on with this dispute. It's not just one lawsuit, but there have been multiple lawsuits. There's also pending legislation. So it's not one single thing at this time.
Yeah, it's very complicated. As for that ruling 3 weeks ago in federal court, what was that all about?
There's actually been 2 federal court rulings. The one that you're talking about, it's the Arizona federal court, and what happened there was essentially the state of Arizona and the Gila River Tribe and the Salt River Tribe, who are all bordering here in Phoenix, brought a lawsuit against the Tohono O'odham Tribe, essentially contending that the deal that was struck when the original gaming compacts were negotiated in the state of Arizona for gaming, not just for the Tohono O'odham Tribe, but for all the tribes, did not intend that there would be an additional casino built in Phoenix. I mean, there's a lot of other legal issues in that, but that was kind of the crux of it.
What does that gaming compact say regarding new casinos in the Phoenix area?
Well, and that's what the judge came down on, ruled specifically that the four corners of that contract did not specifically prohibit another casino in the Phoenix area. And that was the whole argument around the case, was that there was intent that the Tohono O'odham Nation, they already knew that they wanted to have this casino built in Glendale, but they didn't disclose it to anyone else while they were negotiating the compact. But the judge essentially said, look, I'm going to look at the contract itself. What does it say? The contract did not have specific language in there prohibiting it. And he said, based on that, I do not see a claim here. But he left it open. There is still one remaining issue in that lawsuit, which he's asked both sides to submit more briefing.
And is that the issue of what exactly the state understands this compact to say?
Yes. I mean, it really comes down to the intent. What did the state understand it was negotiating in this compact in terms of casinos and where they would be located? And also, who was it that was the representative of the state? Who is the state? Is it what the governor understands? Is it what the voters understand? Because the voters were the ones that passed Proposition 202 approving the compacts. And so that's part of the argument here, is what was understood when this compact was being negotiated. So the judge is asking for a little more evidence, a little more briefing to go behind what was going on.
Does it matter what the tribe knew about the state's understanding?
Maybe. That's also, the judge wanted briefing in terms of not only what did the state understand and was the state's understanding reasonable, but also what did the tribe know that the state knew.
And again, not to get too complicated here, but why is understanding so important to this judge?
Well, I think it's important because these compacts were approved through Proposition 202, which was the voters. And so I think the judge really wants to make sure that this is done with some intent about what the people of Arizona wanted.
Now, correct me, I haven't heard of this in a while. Glendale's efforts to annex that land, is that still in court?
That was one of the lawsuits that was brought early on. The tribe brought a lawsuit to dismiss or basically prohibit the state or the city from doing that. And that's essentially been through the whole court process. The tribe won on that, and it's essentially exhausted all appeals. So I think, when I say I think safely that issue itself, that legal issue, is now resolved and dead.
Because I wasn't sure if they were allowed, the tribe was allowed to go ahead and put this thing into trust yet, or if that was still kind of hanging.
Well, there's yet a third lawsuit.
Okay.
There was another lawsuit brought, which is still pending, and that lawsuit was brought by the state of Arizona again, and the Gila River Tribe and the Salt River Tribe, against the Secretary of the Interior. And the Secretary of the Interior is who has the authority and the power to take land into trust for tribes. So they brought a lawsuit saying that you don't have the authority to take this land into trust because this all goes back to the original act permitting the land to be taken into trust in the first place, which is the Gila Bend Act, which was passed by Congress to help the tribe replace traditional lands that had been flooded by a U.S. government dam built back in the 70s. And so under the Gila Bend Act, there were certain conditions that had to be met for the tribe to buy replacement land. And one of the conditions was that it can't be land that is within city limits. And the tribe went and bought this land in Glendale, It's surrounded by sides, 3 sides of Glendale surround it.
Right.
So it's essentially a county, unincorporated county island in the middle of Glendale. So that issue has been litigated where they have challenged the Secretary of Interior saying you do not have the authority to take this land into trust because it doesn't fall within the Gila Bend Act. Well, the federal court judge here in Arizona disagreed and said, nope, it falls within the act, it's all appropriate, end of story. So, of course, that has been appealed to the Ninth Circuit Court of Appeals. The Ninth Circuit ruled in September. They agreed with the Arizona judge and said, we agree with you. The state then asked for reconsideration of that decision, and just in the last week, the Ninth Circuit did reverse part of its opinion and said that we think there is some ambiguity of what is meant by within the city limits.
Oh my goodness. Last question here. In the grand scheme of things, a 30,000-foot view, why does the tribe keep winning, or at least getting favorable rulings, and why does the state and the city keep losing?
Well,
I mean, it just seems as though this issue should be resolved by now because the scoreboard looks like a lopsided game.
You know, I think the state and the other parties involved in this would probably disagree that it's lopsided, and obviously the Tohono O'odham tribe would concur with you, saying that it is lopsided. But that's the beauty of the law. That's why I enjoy practicing law, is that there's always different arguments to make, and depending on the judge that rules on it or looks at it may have a different viewpoint. So it has been, to date, the tribe has been winning a lot of the battles, but will the war ultimately be won by them? I don't know.
Yeah, that's a good way to put it. Great information. Good to have you here. Thanks for joining us.
Thank you very much.
Apple, the high-tech giant, is being criticized as one of the higher-profile U.S. companies moving profits offshore in an alleged effort to avoid U.S. taxes. Here to talk about the issue of profit shifting is Adam Chodorow. He's a tax professor at ASU and Associate Dean for Innovative Ventures at the O'Connor College of Law. It's good to have you here. Thanks for joining us.
Well, thank you for having me.
What is this controversy involving Apple and taxes?
Well, what Apple has managed to do is to shift its profits overseas in a way that actually allows it to avoid paying taxes on a huge portion of its income.
And Apple recently testified, an executive, I think that the new Steve Jobs, I think, did this, or someone close to him. They paid $6 billion of taxes last year at a 30% rate. Valid?
Not really. So the U.S. has what we call a territorial tax system, or rather, a worldwide tax system, where the idea is that we're going to tax you on income wherever you earn it. But we also have this deferral system, where if you earn the income overseas, you don't have to pay tax on it until you take the money back to the United States. And so what Apple and a number of companies have done is that they have figured out a very clever way to shift income and have it appear to be earned overseas, subject to deferral and not subject to any U.S. tax.
Now, subject to deferral, meaning eventually that's got to come back home, doesn't it?
If they bring the money back home.
Yes.
But what happened, can't remember how many years ago now, about 5 years ago, is that they convinced Congress to have a tax holiday where they were allowed to bring home hundreds of billions of dollars at a very low, a 5% tax rate. And so since then, companies like Apple have stockpiled something in the hundreds of billions of dollars again in the last 5 years. And now they're saying, hey, this money is trapped overseas. We'd love to bring it home and fix the economy and help you, hire people, et cetera, but we can't because of the tax rate. So could you please give us a tax holiday
They're just
again?
waiting on that holiday again, aren't they? And apparently Apple now with this worldwide taxes, only 14% as opposed to the 30%, something along those lines.
Correct. And what Apple has done is actually far more clever than many others. So the general idea is that you want to shift profits to a country with low taxes. So let's say you make an Apple phone and it costs you $10 to make and you sell it for $100. That's a $90 profit. If you do that here in the United States, then you pay tax on the $90 profit. But what if you Apple, make it through a subsidiary in, say, a low tax country, and it costs you $10 to make, but now you charge Apple US $98 for the phone.
Yes.
So now you've got all this profit occurring in this low tax country. And when Apple sells it in the U.S., it reports $2 of profit. So, but Apple's taken that even further because they figured out a way to say basically, look, the company that is making this profit, it's subject to deferral in the U.S., no U.S. tax. But they went to Ireland and set it up in a way where the Irish say, well, actually, it's not subject to Irish tax either.
Yes.
So it's not that they're paying low taxes on this to another country. In fact, they're paying no taxes on a lot of the income they earn.
How common is this?
It's getting more and more common because once one person figures out how to do this, there are a lot of copycats. And so what you'll find is that the CFOs of a lot of the large multinational companies have come to understand that tax management is sort of a big part of their job, and they are constantly looking for ways to reduce their taxes.
What are these other, the Irelands of the world, what are these other countries saying about this? Are they willing partners? Are they getting a little tired of it? What's happening?
Sadly, a number of them are willing partners because what they get, it depends on the structure. So sometimes what they're getting is U.S. moving manufacturing over to their country. So they'll say, it's basic tax competition. If you build it in the U.S., you're going to pay a ton of taxes. If you build it in Ireland, you'll pay less. Well, what does that mean? That means that Ireland gets a business which employs people. And so in those cases, Ireland has everything to lose. The latest ploy that we're talking about here, where neither the U.S. nor Ireland taxes it, I don't think either of the countries really want that. That's a crack in the system that Apple has found and is exploiting. But Ireland doesn't really gain there because that's just a paper game that's being played.
What are some of the other countries involved, both in profit and expense shifting?
Well, people use the Netherlands. There's obviously the Cayman Islands, and there are a whole bunch of tax havens, oddly enough, in warm, sandy places that people tend to go. But there are a whole bunch of countries. A lot of the bank secrecy laws in Europe actually allow people to, create bank accounts that people don't know about and do all kinds of interesting tax planning.
How is this all playing on Capitol Hill? Are we going to see changes afoot here?
It's hard to say. On the one hand, when something like this happens, I have hope. I think, finally they're going to fix it. But one of the solutions that's being bandied about is, well, the problem is that we're trying to tax people on their worldwide income, and we should be territorial. We should only tax income earned in the U.S. and let income earned elsewhere be taxed elsewhere. And that would, on some level, exacerbate the problem because there are going to be more and more of these cracks in the system that people will find. There's a lot of talk now about lowering the corporate tax rate because the idea is that this is happening because our tax rate is so high, and our corporate tax rate is high. The nominal rate's high, but the effective rate, what people actually pay, is far less because there's so many ways to game the system and shift either income overseas or take expenses from elsewhere and apply them against U.S. income.
Last question real quickly here. Country by country reporting, at least so everyone can see what's going on and where it's happening. Is that possibly on the horizon?
It may be. I mean, we're making steps now. We're trying to get information reporting automated and built up. But it's really hard to get into the financials here.
All right. Good information. Good to have you here. Thanks for joining us. We appreciate it.
My pleasure.
And Wednesday on Arizona Horizon, we'll have the latest on the fight over Medicaid expansion in our weekly update with the Arizona Capital Times, and we'll learn about a new commercial project in Mesa that looks to extract biorubber from a desert plant. That's at 5:30 and 10 on the next Arizona Horizon. That is it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of 8, members of your Arizona PBS station. Thank you.